licensed attorney. Prior to that, I worked at Farris as a law clerk for 2 years. So I've been in the law game for about 10 years. I've been incorporating businesses ever since I got my law license. And I've been helping small businesses grow in Wilson County for the past 8 years. So why is it important to pick the correct legal structure for you? The first reason is because you really don't want to risk your personal assets. If you don't have a corporate structure to protect you, your family, and all your personal assets could be at risk. And the second thing is that you want to avoid paying taxes, but you don't want to avoid paying taxes the wrong way. You don't want to avoid that. You don't want that tax liability. You don't want to shuck that responsibility, end up indebted to the IRS, and you don't want to pay unnecessary taxes to the state and federal government. There are 4 main different types of business structures. The first is a sole proprietorship. The second is a partnership. The next is a limited liability company. And the last is a corporation. There are some other structures that we could talk about, venture capital structures, nonprofits, but in regards to the nonprofits, I think that's a talk that we're going to have at a later time. I think July 27th, 16th, somewhere in there. A sole proprietorship, that's the easiest one to do. That's a small business. Essentially, you're a one-man gang. It's an automatic designation. A sole proprietor has a complete control of his business, and you can operate it as a trade name. We'll talk about that towards the end. A sole proprietorship in and of itself makes you extremely liable for any of the bad stuff I mentioned previously. You're solely responsible for your income tax and your corporate tax liability. You're also liable for any bad things that happen if you get sued. If there's an accident, anything like that, you become personally liable for any of the negligence or the intentional actions as a result of your business transactions. It's a really good choice if you have a low-risk business or you're just testing out a new idea. One big caveat to this: you can operate as a sole proprietorship, but absolutely do not add a corporate designation to the end of however you decide to do business just because you think it looks good. That will result in the creation, whether you want it to or not, of a de facto corporation. And becoming a de facto corporation essentially means that your people can and have the ability to treat you as a corporation, and that might not be something you want, especially in the early stages of your business. The more people you add to something, the more complicated it becomes. The simplest structure for 2 people is called a partnership. North Carolina general statutes call it an association of 2 or more people to carry on as co-owners of a business for a profit. It's a good choice for multiple owners, again, that are running a low-risk business, or for professional groups like, for example, Farris is a professional association, but it's a partnership association. Or it's a partnership as well. You see it a lot with doctors and medical groups. And also it works with groups that want to test out their idea before getting into a more formal business structure. Unless there's a partnership agreement, the general statutes that govern partnerships are all found in Chapter 59 of the North Carolina General Statutes. You need to file a creation filing with the Secretary of State, and there are 2 big types of partnerships. The first is a limited partnership, and the second is a limited liability partnership, and they pretty much are what they sound like they are. In a limited partnership, one partner has unlimited liability, which means the majority of he essentially becomes the fall guy for the partnership, and the remaining partners just have limited liability, which means their liability is limited up to the extent that they put in to the partnership. Partners with limited liability tend to have limited control. There's that saying, if you want to beat the man, you want to beat the man. But if you want to be in control, you have to be able to accept, or with great power comes great responsibility. And in order to have the power in the partnership, you have to be able to accept all the responsibility that comes along with the partnership. As I indicated earlier, all partnerships are governed by a partnership agreement, and the profits are typically passed through to your personal income tax returns. Limited liability partnerships sound exactly what they are. sound exactly like what they are. They limit your liability. An LLP protects the partners from the actions of the other partners. So if partner A decides to commit fraud on customer A, partners B and C aren't liable for the fraud committed by partner A. This also protects each partner against the debts for the actions of the partner. So if partner A decides to go into debt or starts to borrow against the partnership, then partners B and C aren't liable for the debt partner A took out. One thing to remember is that a partnership is like a marriage. You need to pick your partner wisely. As part of your partnership, you have an absolute duty to tender on demand true and full information that affects the partnership. You got to act as a fiduciary, which means you have to act in a financially responsible manner to your partner. You always have the right to a formal account, and then as to the extent of property rights, they're either specifically laid out in the partnership. You can have an interest in the partnership, or you can have a right to participate in the management of the partnership. Partnerships continue until dissolution. Dissolution is something we'll get into a little bit later, but essentially dissolution is corporate death, which means partnerships will continue until a triggering event. It can be caused by a violation between partners and an unlawful act, death of one of the partners, bankruptcy, or in extreme cases, if the partners do some no good, very terrible, very bad things, by decree of the court. Alimony. In a partnership, when dissolution occurs and it's caused by a bad act, death, or bankruptcy, each partner is liable to the other partners for the share of any liability created by the partner, as if the partner had not been dissolved, unless everyone else is dissolving too, or the dissolution is by death or bankruptcy. The partner acting for the partnership had knowledge or notice of the death or bankruptcy. So, for example, if partner A is embezzling funds or is committing fraud against their customers, that partner becomes liable on dissolution as a result of the no good, terrible, very bad things. It's sort of like, it's analogous. It's analogous essentially to an at-fault divorce in North Carolina. If somebody does something bad, they become liable to their partner. Next, we'll talk about limited liability companies. A limited liability company is kind of a cross between a corporation and a partnership. There are two types of limited liability companies, member managed and manager managed. Those are essentially exactly what they sound like. They're either managed by the members of the company or they're managed by a manager appointed by the members of the limited liability company. It protects the personal assets of the members in most instances, but specifically in the case of bankruptcy or lawsuits. It is a distinct entity from its interest owners, and the governance for a limited liability company comes from its operating agreement, which is essentially an agreement that everything in corporations for the most part is exactly what it sounds like. It's an agreement that everybody agrees the company will be operated by. But if it's not in the operating agreement, then the North Carolina Limited Liability Company Act applies. You've got to file in order to create a limited liability company, you've got to file what's called Articles of Organization with the Secretary of State. Articles of Organization, the filing fee for that is $125, and then I think it's +2 if you do it electronically. And then limited liability companies will last forever until they are dissolved. Operating agreements, like I said, govern the affairs of the LLC. They lay out what everybody is supposed to do and what the company officials do in relationship to the people who own interests. If there's a conflict between the operating agreement and what's filed with the Secretary of State, the operating agreement will prevail. But the operating agreement doesn't vary or nullify the limited liabilities Limited Liability Corporations Act, which means if your operating agreement is void against public policy, if it says you're allowed to do some illegal things, like, for example, if it says we will not give accountings to our interest owners, or we won't give updates, or we won't be transparent in our bookkeeping to our interest owners, it's void as against public policy, and the Limited Liability Corporations Act prevails. And like I just indicated, it does not diminish the rights and protections under the Act or the rights and protections of the members. So you can't write articles of an operating agreement that's oppressive to the membership of the LLC. Corporations are like giving birth to a brand new baby. They can make a profit, they can be taxed, and they're legally liable on their own. Corporations are also called C Corps by the IRS. They pay tax on income and dividends to shareholders on personal tax returns. Their ownership is established by shares of stock. This is what sort of differs between limited liability companies and corporations. A corporation will have shares of stock, where a limited liability company its ownership will be split up into percentage of interest. Corporations live separate and apart from their shareholders. A shareholder can sell its shares and keep the business, and the business keeps on moving. They're a good choice for any kind of higher risk business or businesses that need to raise capital or money fast. Part of the business plan is to eventually sell the business. In order to register your newborn baby corporation, you have to file what's called Articles of Incorporation. The filing fee for Articles of Incorporation is also $125, and it's governed by the North Carolina Business Corporations Act, and that's Chapter 55. Unlike LLCs that are governed by operating agreements, or partnerships that are governed by partnership agreements, just to add a fun wrinkle into this, corporations are governed by what's called bylaws, and those contain provisions for managing the business and regulating the affairs of the corporation. They dictate how, when, and what notice is required for shareholder meetings or meetings of the board of directors. One of the main questions I get anytime somebody comes in and they talk about wanting to incorporate LLC versus corporation, or what they need to do, inevitably, a lot of the small business people come in and say, hey, I want to be an S corporation. You don't file for an S corporation designation with the Secretary of State. It's a tax designation given to you by the IRS. And the best advice I can ever give anybody is to talk to your accountant about what the implications of being an S corporation are. But S corporations are corporations that elect to pass their corporate income losses, deductions, and credits to their shareholders for federal tax purposes. In order to qualify as an S corp, you have to be a domestic corporation. You can only have an allowable type of shares, typically just common stock, no more than 100 shareholders, so you have to be a smaller corporation with one class of stock, and you must not be an ineligible corporation, so you can't be a bank or an insurance company or a domestic international sales corporation. Putting the baby to bed, or putting the baby to sleep, which sounds a little macabre now that I say it out loud, all corporations, just like the other entities, are subject to dissolution. Dissolution can be brought about by the shareholders. It can be brought about by the court. Triggering things that bring up judicial dissolution include bad acts, breaches of fiduciary duties, bankruptcy, and lastly, the last way that dissolution can occur, and this can also occur with LLCs, is administrative dissolution. So if you do certain things, or you fail to register properly with the Secretary of State, or fail to continue to follow up with your annual reports, or not answer questions if asked by the Secretary of State, the Secretary of State can dissolve your corporation. And now just a little bit of practical information for everybody out there. LLCs and corporations require a registered agent. That person is the person that accepts service and receives all legal notices for the corporation. You need to get a registered agent you can trust. Some people use lawyers, some people list themselves, some people use corporations to accept service for them. I always am weary of using one of these big corporations that accept service, like CT Corporation is one of the big ones that's utilized in Raleigh. The issue for that is that if you are served with a lawsuit or if it's time sensitive, you may not get what you've been served with in time. And if you don't receive what you've been served with in time, then then you may suffer the consequences of not being able to respond in time. So in the context of a lawsuit, you have 30 days to respond after the date of service. If CT Corporation misplaces your paperwork or loses your paperwork, on that 31st day, the person who files a lawsuit against you could get what's called default judgment, which means you automatically lose because you didn't participate in the lawsuit. You're going to get corporate books no matter if you become an LLC or corporation, or if you're a partnership association, you should keep some manner of corporate books. The law requires, if you're an LLC or a corporation, that you update your corporate books at least yearly. Annual meetings, if you have shareholders, if you decide to become a corporation, you need to have those annual meetings. Annual reports, like I indicated last time, or like I indicated previously, if you do not file your annual reports, the Secretary of State can dissolve your corporation. That's one of the things that gets lost in the shuffle. People move, people don't change the registered agent, people don't get the notices from the Secretary of State, they forget to file their annual reports, and next thing I know, they're not authorized to act as a corporation, and they lose a lot of the protections they get as a corporation because the Secretary of State has decided that you are no longer a corporate entity. In regards to insurance, please get it. If you're going to operate as any kind of business, no matter what kind of business you get into, particularly if you're incorporated and you really, really, really want to insulate your personal assets from potential wrongdoing, you need to get insurance that covers the business. And I don't mean a minimum limits policy. You need enough insurance to make sure if something catastrophic happens, you're covered and your loved ones are covered. And a lawyer, I'm not saying to put one on retainer, but you need to get one that you trust and one that you can talk to. Trade names. I told you we'd circle back to trade names. Do you want to have a trade name? You don't have to have a trade name. It's typically when you file for your employee identification number, which is something you do, particularly if you want to have employees, or if you're an LLC or corporation, and you want to file taxes and eventually get your tax designation, or even open a bank account in the name of your corporation, you need to get an EIN. But anyway, it's typically just the name of your business without the designation at the end, so without the Inc. at the end or the LLC at the end. But if you are doing business as, so if you're John Smith doing business as Smith's Lawn Care and Snow Cone Emporium, you need to file a certificate of assumed name with the Register of Deeds in your county. You can typically pick those up at the actual Register of Deeds. I think there's a small filing fee associated with that, but you are required to do that under North Carolina General Statute 66-68. And with that, I think we're open to questions. As far as which kind of corporation is best for you, it's really a matter of preference and where you see your corporation going and doing and what you think you're going to be when you grow up. What's important to know about corporations is that you can start off as an LLC and become a C Corp or a corporation. The other thing is that if you don't like where you're at and you want to start fresh, if you do enough paperwork, you can shut down or dissolve one corporation and you can start fresh again. So you're not necessarily always bound to one corporate designation. As your needs change and as time goes on, you have the ability to change, and the law allows that. But with that, I will open it up to any questions anybody might have.